This lecture will be devoted to one of the landmark judgments delivered by Supreme Court 45 years ago in the year 1980 on 5th August regarding the Azad Rickshaw Pullers Union vs. State of Punjab. So, the very question at present arises why it is in news. So, the Supreme Court judgment of August 6, 2025 is relevant here to discuss. So, this made over the use of handful rickshaws even after 80 years of country's independence. The Supreme Court on August 6, 2025 directed the Maharashtra government to stop the inhuman practice within 6 months in Matheran and switch to e-rickshaws instead, permitting such a practice which is against the basic concept of human dignity in a country like India, which is a developing country, belittles the constitutional promises of social and economic justice as it was expressed by the bench comprising Chief Justice B.R. Gawai and Justice K. Binod Chandra and Justice N.B. Anjaria. The bench, as a result, had a complete stop on handful rickshaws in Matheran in Maharashtra. The state government was directed to instead explore the possibility of giving e-rickshaws to locals in Matheran, a hill station thronged by lakhs of tourists in peak seasons on rent as done by the Gujarat government in Kevadia. As Sardar Patel's statue existed as one of the tallest statues at Kevadia in Gujarat is located on the Sadhu Bet Island on the Narmada, and the authorities have given e-rickshaws to locals on rent. So the bench chastised the practice of using manual rickshaws even after 80 years of independence and almost 75 years after the Constitution came into force, calling it inhuman and against the basic concept of human dignity. To continue such human practice being enacted and promise social and economic justice to its citizens as provided under the Constitution of India. However, it would be betraying the promise given by the people of India as given to themselves. The bench expressed this view. The top court referred to a 45-year-old judgment, and that is Azad Rickshaw Pullers Union vs. State of Punjab case, which held cycle rickshaws were inconsistent with the preamble's place of social justice. As Chief Justice of India, Justice Gawai lamented, it is really unfortunate that 45 years after the observation made by this court in the case of Azad Rickshaw Pullers Union, the practice of a human being pulling another human being is still prevalent in the town of Matheran in Maharashtra. So further, he added the very question that we asked ourselves is whether this practices allude to the constitutional promise of social and economic equality and social and economic justice. The answer will unfortunately have to be in the negative. The bench further observed that poverty often forced people into such work, but stressed economic compulsion could not justify degrading human labor. So, citing the 1982 judgment in People of India for Democratic Rights, the bench reiterated exploitative work conditions amount to forced labor as it is defined and provided under Article 23 of the Constitution. Referring to Matheran, the bench said it is an eco-sensitive hill station where automobiles are banned except for emergency vehicles, and it has long relied on hand-pulled rickshaws for transporting tourists and goods, directing hand-pulled rickshaws to be phased out within 6 months. The Chief Justice of India ordered laying off waiver blocks from Maneka to the Shivaji statute. The bench further cautioned the state government of Maharashtra not to make an excuse of lack of funds, as it will not be accepted for non-implementation. So, the bench says expressed that we clarify that non-availability of funds cannot be an excuse for non-implementation of the aforesaid scheme. So we earnestly hope that the state would render necessary assistance in stopping such an inhumane practice. Issuing a slew of directions, the bench said the state government is permitted to lay down paver blocks from Dasturi Naka, that is the bus station, up to the Shivaji statute in Matheran. It further directed no paver blocks would be laid on the internal road and the trading routes in the hill station. The Matheran Monitoring Committee, under the chairmanship of the Matheran collector constituted under the eco-sensitive zone, was ordered to identify the genuine rickshaw pullers. The number of e-rickshaw required will also be decided by the committee after considering the ground reality as it was expressed by the Supreme Court bench. The top court said the remainder of the rickshaw could be allotted to tribal women and other persons in Matheran to ensure a speedy livelihood. Automobiles are banned in Matheran due to ecological concerns. Matheran's special status was recognized by the apex court, and the Ministry of Environment and Forest issued a notification on February 4, 2003 declaring the hill station and the surrounding region as eco-sensitive zone. So in this context, as the Supreme Court bench made reference to Azad Rickshaw Pullers Union vs.State of Punjab case, would like to discuss about the landmark judgment relating to Azad Rickshaw Pullers Union vs. State of Punjab, which was delivered by the apex court on August 5, 1980, the case of Azad Rickshaw Pullers Union vs. State of Punjab was adjudicated by the Supreme Court of India on August 5, 1980. This landmark judgment addressed the socio-economic plight of rickshaw pullers in Punjab, focusing on the legislative efforts to eradicate the exploitative practices of cycle rickshaw owners. The primary parties involved with the Azad Rickshaw Pullers Union representing the rickshaw pullers and the state of Punjab, alongside other municipal authorities. The core issue revolved around the Punjab Cycle Rickshaw Regulation of License Act 1976, which sought to regulate the rickshaw pullers. So, in this case, the President cited while the provided judgment text does not explicitly cite prior cases, it implicitly builds upon the constitutional jurisprudence that emphasizes social justice and the role of the state in uplifting marginalized sections. The reference to Article 38 of the Indian Constitution underscores the commitment to secure a just social order, reflecting principles established in earlier landmark cases such as Keshavanda Bharati vs.State of Kerala of 1973 and Maneka Gandhi vs. Union of India in the year 1978. Through the very judgment upheld by the Supreme Court. In this landmark judgment, they upheld the validity of the Punjab Cycle Rickshaws Regulation of License Act 1976, emphasizing its alignment with constitutional mandates for social justice. Particularly, Article 38, the court recognized the act's objective to liberate rickshaw pullers from economic exploitation by banning non-owner rickshaw drivers and promoting ownership among the pullers through interest-free loans and supportive financial schemes. The judgment outlined a comprehensive framework that mandated municipal authorities and financial institutions to collaborate in facilitating rickshaw pullers' transition to ownership. The apex court constructive approach transcended mere judicial review, fostering a viable socio-economic solution by integrating legislative intent with practical mechanism for implementation. So the legal reasoning as cited here, the court approached the case from perspective of constitutionalized humanism, prioritizing the socio-economic upliftment of the rickshaw pullers over strict legalistic interpretations. It acknowledged the genuine intent behind the Punjab Cycle Rickshaw Act and evaluated its provisions not solely on technical grounds but on their merit in promoting social justice. The legal reasoning was rooted in the symbiotic relationship between legislative measures and judicial effort to create effective remedies rather than the existing hardships by facilitating interest-free loans and establishing a cooperative framework involving municipal authorities and financial institutions. The court ensured that the act translated constitutional promises into tangible benefits for the rickshaw pullers. The lasting impact of this judgment, which set a precedent for judicial activism aimed at social welfare, demonstrating how courts can play a pivotal role in shaping policies that address economic disparities. It underscored the necessity of combining legislative actions with supportive schemes to achieve many meaningful social justice. Future cases involving labor rights and economic empowerment can draw inspiration from this holistic approach where the judiciary actively collaborate with legislative and executive branches to devise comprehensive solutions. Additionally, the emphasis on procedural fairness and the elimination of all kind of exploitation and inequality. So there are certain important concepts in particularly we'll discuss regarding the concept of judicial engineering and social engineering, the proactive role of the judiciary in crafting innovative solutions and frameworks to address social issues beyond merely interpreting laws could be cited as a kind of social engineering as propounded by the American jurist and philosopher Roscoe found in converting it in Indian judiciary as judicial engineering. So now we would like to conclude the very discussion on Azad Rickshaw Puller's Union vs. State of Punjab judgment stands as a testament to the judiciary's role in fostering social justice through collaborative legislative measures by upholding the Punjab Cycle Rickshaws Act and providing a structured scheme for rickshaw pullers to achieve ownership. The Supreme Court not only addressed immediate economic grievances but also laid down a framework for future judicial intervention aimed at socio-economic upliftment and to achieve socio-economic justice. So it would be possible only if that could be actively translated into the well-being of the society and in particularly those sections of societies who are being exploited and depressed and degraded in the society due to economic difficulties and economic inequalities which in particularly in the preamble of the constitution which itself envisages to achieve socio-economic justice and that socio-economic justice as a direction to the state under the directive principles of state policy under part 4th of the constitution and in particularly under article 38 of the constitution of India gives direction to the state to eliminate any form of socio-economic injustice and exploitation by bringing legislations and for in particularly implementing such legislative enactments to eliminate and to remove socio-economic exploitation and injustice from our social order.